share my vision of Michigan's energy future. And I would say simply that it's one based on free market principles, freedom, competition, consumer choice. In every other aspect of our lives, we see these principles at work every day, day in and day out. We know they work. We know that competition puts downward pressure in the marketplace on prices. So if we want to have more affordable electricity and other energy in Michigan, it seems to me that common sense dictates we've got to have competition and consumer choice as one of our principles.
We're here today with Gary Glenn. Gary represents Michigan's 98th House District, which includes portions of Bay City or Bay and Midland counties, Gary's the chair of the House Energy Committee, and he's here at the Mackinac offices today to talk to us about electricity choice. So the first question that I had is the issue of electricity choice. You know, we were just sitting here talking before we started. It's pretty complex. It's got a lot of acronyms. It's difficult to understand everything, but there are a few specific issues that are impacting Michigan residents today, right now. One of those is what's called a local clearing requirement, or an LCR. So why is an LCR important to Michigan residents? What does it mean? And then what is the government, through the MPSC, or the Michigan Public Service Commission, what are they doing that makes the LCR so important right now?
Well, I don't agree with current policy, but right now, by law, the two major monopoly utilities on a regional basis, DTE and Consumers, have a 90% guarantee of market share in Michigan. Only 10% of the electricity that's generated in Michigan can be bought from somebody other than those two big regional monopolies. It's called our Electricity Choice Program. Michigan used to have a program under which everybody was free to choose, but in 2008 that was capped at only 10%. I'd like to see us go back to a situation where everybody is free to choose. But the legislature, in the last legislative session, expressly intended to preserve and protect that 10% competitive market. What the Public Service Commission now is threatening to do, in the face of warnings from their own staff attorneys, is to impose a requirement that requires the alternative energy suppliers who compete with DTE and Consumers to have to buy their electricity for resale, but have to buy it only if it's generated in Michigan at higher cost from their two major competitors, DTE and Consumers. The PSC's own staff warned them that what would result from this is it would drive up electricity rates for about 350 public school districts, thousands of major job providers, manufacturers. It would put the alternative energy suppliers out of business because they would have to buy more expensive electricity, would force their customers to have to go back to DTE and Consumers at higher cost, and would be at odds with the regulations of the regional electricity manager, the Mid-Continent Independent System Operator, or MISO, that operates under federal regulations. So the Public Service Commission's own attorneys warned them that they shouldn't do what they're about to do. And as chairman of the House Energy Policy Committee, I'm doing my best to hold the PSC and its commissioners accountable. I'm going to try to get these attorneys for the PSC in front of the Energy Policy Committee, simply ask them, why did you make the recommendations you did? Why did you warn the commissioners against doing this? Right. And why are the commissioners in the process of doing exactly what you told them they shouldn't do, because it would hurt electricity customers and Michigan's economy?
Yeah, that was a big part of the question that I wanted to ask is, not only did they seek out the opinions of other people, but they specifically sought out legal counsel on this issue. And their legal counsel said, don't do this. So that to me was interesting. And then there was also two other legislators, I believe, who wrote a letter as well and said, don't do this. So what happened with the other legislators? What did they?
There was a letter written by Majority Whip Rob Verheulen and by Representative Chris Affendoulis, both from the Grand Rapids area. The reason they're important is because they were the two sponsors of the legislation, the compromise legislation that actually became law and is Michigan's new energy law. One of the conditions for the deal, the compromise, was that any requirement that would force the competing energy providers to have to buy only electricity that's generated in Michigan by their competitors, DTE and Consumers. That had been taken out of the legislation as a condition of reaching the compromise. Right. So Representatives Affendulis and Verheulen wrote to the Public Service Commission and saying, you're about to do something that is directly at odds with the legislative intent and the express language of the new law, which says the competing energy providers can buy their electricity from any source.
Right, and that's a big part of it too, because when you think about it, the MPSC, the Public Service Commission, is a creature of the government. It's part of Michigan's government. But in this sense, do they answer to the governor or to the legislature?
They really don't answer to anybody. They're unaccountable. And so far they resisted efforts on my part to try and hold them accountable by having these lawyers that advise them, warn them against imposing this requirement that will hurt our economy and electricity customers. But they're appointed by the governor. They're not accountable to the people. And it really rises to the much broader question of who gets to set policy in Michigan, and in this case particularly on energy. Is it the elected representatives of the people, the legislature, the House Energy Policy Committee, the action of the legislature last year in expressly rejecting any in-state generation requirement, or is it three appointed, unaccountable bureaucrats who simply by a 2-to-1 majority vote or 3-to-0 vote get to do exactly the opposite of what the legislature intended and exactly the opposite of what their own assistant attorneys general assigned to the Public Service Commission warned them against doing? They're about to do. And as an outside observer, it's very concerning to think that it looks like the fix is in. That they're going to give the utilities, the two big monopolies, what they want, give the utilities the power to squeeze their competitors out of business, force all the competitors' customers to have to come to the major utilities at higher cost, and put more money in the pockets of the two big regional monopolies. What they're about to do might serve the economic interests of the big electrical monopolies, but it certainly doesn't serve the best interests of Michigan. What we ought to be after is to provide not only homeowners, but business owners and major manufacturers the cheapest electricity we can, no matter where it comes from, to make Michigan more attractive to new business and industry and the jobs that we need. So imagine the legislature passing a law that said you could only buy cars made in Michigan. You could only buy produce at the grocery store if it was grown in Michigan. Obviously, your choice of products would be fewer than it is now, and the price would go up. And that's what they're attempting to do now, despite the legislature saying that's not the intent of the law, and their own attorneys telling them that if you do this, it's going to hurt Michigan's economy.
Right, and so that's, you cited actually in one of your letters to the MPSC, a court case, I believe it was, that talked about where the MPSC gets their authority from. And that part of that, the ruling, I guess, was that they're called a creature of the legislature.
Right.
So, that one was interesting to me, and building on what you've said, is if they actually are a creature of the legislature, and they should be responding to the legislature, and the legislature said very clearly when they passed the two bills, now Public Acts 341 and 342, that we do not want an LCR in this legislation. In fact, we won't sign it if you include an LCR in, and it's only after you got the votes that we would approve it, or sorry, after they removed the LCR that you were able to get the votes to pass it. So it's one of those things where, you kind of almost have to ask who's in charge.
It is a protectionist scheme that the two big utility monopolies were pushing in the last session of the legislature, which the legislature expressly rejected. It was in early versions of the legislation, and they purposely took it out as a condition of getting to a compromise. And for the Public Service Commission now to attempt by bureaucratic fiat to do exactly the opposite of what the legislature expressly said they didn't want to happen as a matter of policy flies in the face of that one Court of Appeals decision from the Michigan Court of Appeals, which said the Public Service Commission is a creature of the legislature created by state law, and that they have no authority except as given by clear and unmistakable language. Well, the clear and unmistakable language of not only the state law, but the federal policy that's used by the regional electricity manager is that competing providers can get their electricity from any source. And as the court said at one point, the word any may be broad, but it's not vague. Any source. And now the Public Service Commission, in the face of their own attorneys' warnings, is scheduled on September 28th to adopt a policy that would force the competing providers to have to buy energy only in Michigan, force them out of business. And another thing that hasn't been discussed yet is that the Public Service Commission's own staff estimates that if you impose unnecessarily, because they say it will have no impact on electrical reliability. It will not make Michigan's electricity system more reliable, but if you impose this local clearing requirement or in-state generation requirement, it will result in a 5% overbuild of capacity. In other words, more new electricity generating plants by 5% than we need to meet the demands of Michigan's marketplace. Well, what does 5% mean? It doesn't sound like a lot. But if you take Detroit Edison's recent filing in which they say they intend to build a new gas-fired electricity generating plant and take the number that they attach, the dollar value required to generate an additional kilowatt of electricity, apply that to Michigan's overall market times 5%, the overbuild, that is $1 billion. And that's not coming just out of the pockets of the customers of the competing small providers that are cheaper. That's going to be coming out of the pockets of all electricity customers, all of Consumers and Detroit Edison's customers, an additional $1 billion out of the family budget, out of the small business budget, going into the pockets of the two monopoly utilities. That's why it's so concerning that the Public Service Commission appears to be prepared to act in the interests of the utility monopolies, even though it's going to hurt electricity customers and hurt our economy and make us less attractive for new business and industry and job creation.
Yeah, and that overbuild, you can see what happens if you look to California. You can see that happening right now where they're overbuilding capacity and literally having to now shut down plants that were overbuilt. So this has been a great discussion. I appreciate your time, appreciate you coming into our offices and kind of helping us to educate the people of Michigan. I'll give you the last word. Anything you want to add as we close up here?
Well, I've tried to focus a public spotlight on the fact that the Public Service Commission's own attorneys warned them that if they do what they're about to do, it will hurt Michigan's economy, hurt electricity customers. I invited those three attorneys to come before the House Energy Policy Committee and explain their reasoning, why they told the commissioners it would hurt our economy and electricity customers. The Public Service Commission has initially said, no, we're not going to let our attorneys come answer questions. And we're talking about counsel that was given to the Public Service Commission in a public document that is available on their website. This is not a private communication between the attorneys and the Public Service Commission. They can't make any claim of attorney-client privilege. But they're attempting, I think, to stonewall. The chairman of the Public Service Commission said she would come testify. Well, that's disingenuous because she knows and we know that as long as it's still pending before the Public Service Commission, she can't comment on the issue. So it's disingenuous for her to say, I'll come testify when we know her answer to every question about the relevant issues before the commission will be, I can't comment. But the attorneys are on record in writing in a public document. They can't refuse to comment on something they've already voluntarily made public. So I would encourage Mackinac Center for Public Policy supporters, those who share our belief in free markets and freedom of choice, to contact their legislators, contact the Speaker of the House, Tom Leonard, and urge their legislators to support my efforts to focus a public spotlight on what's going on behind the scenes. Why does the Public Service Commission seem so hell-bent in the face of their own attorneys' warnings not to do this, to do something that's going to hurt Michigan's economy, be at odds with the federal rules and regulations, be at odds with what the legislature says its intent was, and doing this even though their own attorneys are warning them not to? Why? That's the major question we've got to answer before they make a final policy decision on September 28th.
And that's the big day that's coming up, is September 28th. So, all right, Gary, thank you very much for your time. I appreciate it.
You bet.